Without objection, I now recognize Representative Rob Andrews of the 1st District of New Jersey, a member of the full Education and Labor Committee and chair of the Subcommittee on Health, Employment, Labor, and Pensions, for 5 minutes to make an opening statement. And Mr. Andrews, you're welcome to stay for questions.
Thank you.
If you'd like.
Thank you very much, Madam Chairwoman, and I thank you and the ranking member for your courtesy in giving me this opportunity to express my thoughts on a topic on which I care deeply. I thank you, Madam Chairwoman, for being an aggressive and dynamic chairwoman in the few weeks that you've sat and held the gavel. I think you've done more in a few weeks on these topics than some of your predecessors did in a decade and a half, and I'm very grateful to you for your leadership. This morning, one American got up and went to work on a cement mixer, and the person who lives next door to him got up and went to work on the back of a trash truck, working for the town in which they live. If, God forbid, today there was an accident on the cement mixer, the full power of the OSHA statute would be there to either prevent or protect the worker or deal with the consequences of that accident on the cement mixer. But if there's a looming problem on the trash truck, or if, God forbid, there's an accident on the trash truck, the public worker has no recourse and no protection to speak of, has virtually none in 26 states. Now, why is this? Why should the law draw a distinction between whether you work on the back of a cement mixer for a private contractor or on the back of a trash truck for the county? I don't think it should make that distinction. And the purpose of the legislation I've introduced and that Ms. Woolsey's been so kind to work with us on is to eliminate that distinction. Now, I've heard three arguments, I should say, as to why we should continue to have this distinction in the law. That the law should protect the person working on the back of the cement mixer, but not on the back of the trash truck. The first argument is that, well, it will raise taxes by too much and cost local governments too much money to impose this requirement on local governments. I have not seen a shred of evidence that bears out that conclusion in any of the states that have aggressively and proactively protected worker safety. And I would invite any of the panelists who would disagree to tell me why that's not true. I think the opposite is true. I think that employers that are diligent and careful in protecting their workers spend less money on workers' comp claims, on health care claims, on litigation, on all the other problems that come with workplace injury. I think the evidence is rather compelling. The insurance industry would back this up, that employers who are careful about worker safety are more profitable and more efficient and spend less money on those who do not. I think it's good business to be careful about your workers' health. Second is the argument that somehow extending OSHA protection to public workers would interfere with state sovereignty. We feel very strongly about state sovereignty and the rights of state governments to make decisions that they view as being in the best interests of their constituents. But I think there are some rights which trump that. I think there are some basic protections that every American ought to have, whether they live in Nevada or New Jersey, whether they live in California or Florida. And the idea that the safety of your workplace is a function of the accident of your zip code makes no sense to me. I think someone's life is equally worth protecting in Nevada as it is in New Jersey or California as it is in Florida. And I think there should be a basic and uniform protection of that. The third argument I've heard is that, well, there really hasn't been much of a problem, that this is a bill that is a solution in search of a problem. I wish that were true. I wish that were true. The last time this Congress paid any serious focus on the issue of extending OSHA protections to public employees was in the early 1990s. Since then, virtually no attention has been paid to this subject and nothing has been done. And since then, 8,600 public workers have lost their lives. Were all preventable? I doubt it. Were some preventable? I'm sure. I'm sure. And I think if we had had sufficient protections in state, we would not had that problem and that situation for so many families. I also wanted to add a word of personal appreciation to Mrs. Jones for her presence here today. I think that the mark of true character is someone who deals with tragedy not by dwelling on the hurt and the loss, but by moving on to something positive and doing something as a positive response to tragedy. And your statement here today, Mrs. Jones, on behalf of Clyde Anthony Jones and others like him, I think is a measure of your character, and we appreciate it very, very much. So I understand there are arguments about taxes and spending, and there are arguments about interference with state sovereignty and arguments about the scope of the problem, but I think the record's very clear that employers who are careful about worker safety spend less money than those who are careless. I think the record is very clear that there are certain protections that should not be an accident of where you live and should be a function of your standing as an American worker. And I unfortunately think the record is very clear that there is a very significant problem. 8,600 public workers killed since 1992, 520 in 2005 alone. So I again thank the chairwoman and the ranking member for their courtesy and their indulgence. I thank the panelists for being here today, and I would urge this Congress to take expeditious and wise action on this matter. Thank you, and I yield back.